RFB Legal. The Litigation Series.
My name is Jonathan Chan and I'm a solicitor at Ronald Fletcher Baker's Litigation Department. Now today's topic that I'd like to discuss is the surrender of business tenancies. As you're aware, the current business climate is very uncertain. Many high street firms are facing cash flow issues and many businesses are having to adapt and to explore what possible options are available to them to reduce the current so-called squeeze. Now, many businesses are moving online, many retailers, and one of the possible options available to them is to explore the possibility of surrendering their business tenancies, i.e. to surrender their trading premises and to completely move off-site and to move on to an online business. Now, many of you may or may not be aware that there are a number of methods to surrender a business premises, and that may be through a formal deed of surrender, for instance, or even by operation of law. Now, what we mean by operation of law is a mutual understanding and a mutual clear and unequivocal intention by both parties, i.e. the landlord and the tenant, to surrender the property. For instance, you're the tenants, you vacate the premises, you remove everything out of your premises, and you deliver and hand back your keys to your landlord. Now, your landlord then accepts as a clear and unequivocal act the return of the keys as a surrender of the property. Now, those two methods are relatively simple and are widely used throughout the industry. Where it causes for concern is where you have a protected business tenancy. And what I mean by that is a tenancy which has not been contracted out of the 1954 Act, i.e. the Landlord and Tenants Act 1954. And in particular where a protected tenancy attempts to enter into an agreement to surrender. Now that's to be differentiated from an immediate surrender, i.e. from operation of law or by a deed of surrender. So what we mean by an agreement to surrender is essentially a forward-thinking surrender, i.e. an agreement to, for instance, surrender in say 4 months' time, as opposed to an immediate surrender, as we previously mentioned. Now, you might be asking to yourself, why is that a cause for concern? Now, the reason it's a cause for concern is because the 1954 Act provides a statutory procedure in which one must follow to ensure that any agreement to surrender is valid. So failure to follow this statutory procedure will result in any agreement being void and potentially unenforceable. So at this stage, you may now be asking yourself, how do I ensure that it's a valid agreement? Now, we're not going to delve into the depths of the 1954 Act for the purpose of this short video, but in essence there are two methods. Firstly being the warning notice method, and then secondly the statutory declaration method. Now, both of these methods are quite intricate. There are a number of stages, but at the same time they largely reflect and adopt a similar procedural step as they do for contracting out of the 1954 Act, i.e. contracting out of the protection of the 1954 Act before granting a new tenancy, which will result in a new tenancy which is not protected by the 1954 Act. I hope you enjoyed this short video, and if you need anything else, please feel free to contact me.